A very warm welcome in the third module of week 8 of the course Roadmap for Patent Creation, titled Patent Commercialization. Till today what we have seen is that we have gone through what is patent, then we have seen what are the different types of patent, right? Then we have seen how the procedure for patent grant it is followed. We have seen so many things about the patent. Now you have in week 6, 7, we have 6, 7 and 8. We are just concentrating on your research project or any project, how you can manage it through the IP perspective, that we are just concentrating now. Now, okay, so we are now at the stage that okay, you have filed the patent and now you are thinking of the commercialization of that patent, right? So, we always know that when we are thinking of a patent is obviously mostly it is expected that you are filing patent because you want to create a wealth. It is a property, and from property you are, what we can say, you want to create wealth, you want some benefit from this activity, and then what we can say that this IP property is created and that may be used directly as to create a wealth, or you can use it strategically to explore some benefit from that thing. Okay. So, how exactly that process of patent commercialization occurs? What are the different ways for that? It is actually very vast topic, but in this module we will try to give you some glimpses about that patent commercialization, how exactly it works. So, we will start with what is a need for that, means how it starts, how that process starts for the patent commercialization. You know that you have done that all process for the patent filing, and now the invention, okay, whatever invention is there, that is granted, or it may be just filed, whatever it may be. So, remember one point here, that it is not necessary that you have to wait till grant of the patent for the commercialization. As soon as you file the patent application, you can start the commercialization activity. Rather, we suggest that if you are filing provisional application, then you start immediately working on it. Immediately you can use it for your commercialization activity. Generally what happens, you are an inventor, you want to, if you are thinking of some entrepreneurship activity or some other thing, you require fund. So, it is always necessary that you also want that okay, my idea should not be stolen by somebody, that is also in your mind. So, in this case what is important is that you secure your right by filing the provisional patent application, then whatever that complete and all that thing that you will do, because you know now the timeline and all that thing, but you file that provisional and you can immediately start the activities for a fund generation. So, you can communicate with the angel investors, you can communicate with the bank, and you can start your activity, right. So, commercialization activity, remember, it starts as soon as you secure the priority. Okay. Now, why you need, what is the need for that commercialization? The first thing is that your invention is not a ready to market product, right. That product is not ready for the market now. So, that invention you have to convert into the product, that product which is ready for marketing. So, whatever that process is there from invention to that product, it is a very challenging journey. Generally we call it as a death valley is there, right. Why we call it as a death valley? It is a challenging phase, that how that invention goes from that raw state, from that then scale up, then that pilot and all kind of thing, then your prototype is ready, right. And after prototype, again the scaling up of that product is there, so that it will be a, what we can say, the final product for the market. And then once it goes into the market, then depending on the, what we can say, the need, you can just do the modifications in that product and you can just develop the further expand that business. But this, that is from invention to prototype to this ready to, what we can say, market product. This journey is very important, right. And you have to work on that, what we can say, to go from that invention to the product. The idea, whatever is there in your mind, right, it does not mean that it is useful invention, obviously, and so you have to make sure that how you can convert it into the product which can be a sellable, right. Now, inventions which are useful, that invention, see what happened, that you file a patent, it is not necessary, it is expected that the patent should be commercialized, but many a times you see that so many patents are there, they are not commercialized, right. Invention, we can say it is useful only if the product is marketed well. So, we can say that a good product or good patent is that which is followed the path from that, what we can say, it is like idea stage, it is now filed, invention is, that patent is granted, and obviously it is successfully commercialized, right. So, if everything is, what we can say, done, then we can say that okay, this invention is a very good invention and it is granted and it is marketed also, right. So, that is very important. Okay. Now, what is that path which is generally followed? We can just see it in the, what we can say, diagram kind of thing. So, how it works, like creation is there, then protection is there, and the exploitation is there. Creation is actually your R&D phase, you have just started that thing, right, and then the invention, that disclosure is there and all kind of procedures you follow according to your organization, and then you will take a decision about the protection, right. Patent application will be filed, right, and once you file that thing, then we have seen that exploitation, that is a commercialization will, that process of commercialization starts. It may be a licensing, it may be a sale, it may be a startup, it may be a spin-off, whatever it may be, right. So, any path you will follow and the commercialization will be achieved, right. Now, so this is the, what we can say, in a figure, or in this figure you can see the how that path from that R&D till the market it goes. Now, what are the different ways by which you can commercialize this patent? Okay. First thing is that internal development, that is in-house development. Second is licensing. Third is a joint ventures or partnering, and fourth is a startups and spin-offs, right. So, these are the 4 ways, and by these ways there you can do the commercialization. Okay. Now, how we will see one by one, what is that internal development is there, what is licensing and all kind of thing. Okay. So, let us go in details of that. But before that, we will see what is a due diligence. Before commercialization, we have to do the due diligence. What is the due diligence? It is a legal term, just do not get boggled by this term. Due diligence is like some necessary processes, some, what we can say, important processes you should do. It is expected that you should follow that before commercialization of that patent. Okay. So, what these important processes are there? You should know that where my market is there, whatever your product is there, whatever your invention is there, you should identify them. So, it is like a, what we can say, background search you are doing. You are doing that some processes which are market oriented, some processes which are related to manufacturing, some processes are with a very legal intensive processes are there. So, if you want to, you have to follow some regulations and all kind of thing, all that legal processes are there. So, due diligence will involve all this kind of thing. So, first thing important is as a market. Now, a market also within country you have to identify, or outside country, means if any other countries in the world, if you want to explore that thing, then you have to decide it that okay, where my product will be, what we can say, where the market is, right, where it can be, you can do the successful commercialization of that particular product. So, that is very important, that is the first thing. So, for example, if anything related to what we can say, the heater and all kind of thing is there, then that will be very, if that kind of product is there, that will be of course useful in the areas where you can see that the cold conditions are always there or something like that. So, you have just example I have given, but you can just think of that, okay, where is my market, that is the first thing. Next thing is, that is a legally important thing is a freedom to operate search. Now, that is we call it as a FTO search. This is one of the important search. Everyone who is doing the commercialization of the product, they have to do that thing. What is the meaning of that? We know that patent is a negative right. Whatever you have invented is there. Before commercialization of that, you should know that okay, if you yourself are not infringing the rights of others. So, to check that thing, that you are not infringing the rights of others, and you have complete, what we can say, the right to execute your rights in that particular territory, you have to check it through the freedom to operate search. So, you will do the freedom to operate search, and you will check that okay, you are really the, what we can say, first inventor, you are the right owner, and you will confirm this thing by doing this freedom to operate, right. We have seen that 18 months window is there, and there are chances 18 months window, that is from filing up to the publication, it takes a 18 months time. So, whenever you do search report, what happen, that this 18-month window is always, what we can say, nobody gives you guarantee about that, right. And whenever if something is there, means before your application, that 18 months time is there. So, you are not aware, when you are filing patent, you are not aware about which are the different patents related to that area are filed in that 18 months, right. And possibility is that whenever you are doing that thing, obviously in the examination the care will be taken, means that caution will be taken by the examiner. If that kind of thing is there, definitely your patent will not be granted, definitely. But before grant, if you are starting the commercialization, then it is better to check do the freedom to operate search. Obviously, after grant also, before commercialization, it is always suggested to do FTO search. That is very important, because sometimes the patents that is are there in PCT stage, and if something is there in a PCT stage, that timeline is long timeline, 30 to 31 months timeline is there to the inventor or assignee, and therefore, you have to check that whether that timeline is crossed. If somebody has filed that kind of patent, and suppose that is in a USA, right, and if you want to do the marketing of a same product in India, then the possibility is that you should check that whether it is not in that PCT stage and all that kind of thing. So, so many other things are there, we will not go in detail, but just understand this is very important search. Then what you have to do, that you have to find out whether you alone are able to do all this, what we can say, the processes related to commercialization, like manufacturing, marketing, setting up of R&D, if you are capable of doing all this thing, or you are thinking of any collaborations or partnership. So, you can think about that kind of thing. So, you have a patent, you can think of okay, whether I will require somebody who is expert in marketing, whether I will need somebody who is very good in business development, right. So, you have to think about that thing, and then if you identify that particular expertise, then you can think of a partnership or a collaboration, right. And then you have to decide on the or you have to check the organization strategy. So, for example, if you are from an academic institute and if you are thinking of a commercialization, right, then you should know what is the IP policy of that organization and what is the strategy generally followed by the organization for the commercialization. That is the one thing. If you are a corporate, then the thing is that obviously you corporate in that the business strategy determines the, it is a main strategy which determines the IP strategy, and then that determines okay, which product will be considered for the commercialization. And that, in short, I have told you, but there are so many things, technology strategy is there, business strategy is there, IP strategy is there, all these are very interrelated, and there are so many parameters, procedures to decide on the commercialization of particular product, right. But you should be aware of that the organization strategy is a major decision making factor when you are thinking of a commercialization. So, when we are talking about a due diligence, you are doing the market related or other manufacturing related, whatever that things are there, that due diligence you will do, right. You will see if any expertise you are requiring, then you will do the search according to that, and then the strategy part you will check, and then legal compliances, whatever you want to do, if that you have to do, especially with the pharma companies or the biology products, right. You have to, means if anybody is working in that thing, they have to follow strict regulations which are there in that particular country where you are marketing, and you have to check that also, right. So, this is what the due diligence part is. Now, we will see the pathways. So, we have said that okay, there are total 4 pathways are there, that is internal development, licensing, joint ventures and startups or spin-offs. So, let us see now that what is that internal development is, right. Now here in-house development, you can say internal development as a in-house development. So many times if generally it is general observation, if your patent is a process patent, right, the possibility is that it is you can immediately implement in your organization and you can do the that in-house development, right. That particular patent will be explored in-house within the organization. You have improved your processes, right. That is a one thing. The other thing is that obviously about a product also, if you have that capacity of manufacturing and you have that plant ready for that, then most of the organization obviously, if that is what we can say directed research is there, then obviously when that research is going on, obviously the manufacturing facility and that all that everything goes parallel, and it will be that timelines are fixed, and obviously organization will develop the product and the marketing will be started. So that is a inventor or the assignee who have invented, they themselves will start manufacturing of that or that particular product or a process is explored there, and that product whatever is there that will be marketed. If process is there, that is implemented. That is what the internal development is. Now then the next is a licensing. Most of the time what the thing happen that probably especially in an academic institute, if you see that possibility of commercialization by inventor is generally it is low. Why? Because that commercialization require a different skill of set, invention requires a different skill of set. So the inventor having both skills, that is inventor, that research what we can say R&D skills, and then the business development and marketing skills, and that entrepreneurial whatever the skills are there, if that is there, well and good, then obviously that development can be done and that path will be explored through startups or something like that. But the other way is like a licensing. So here what the thing is there, that the owner, that is assignee, can think of a transfer of right to someone else, right. So technology transfer can be followed. Now what are the kinds of licenses? There are two types of licenses broadly, that is a exclusive license and the non-exclusive license. So these are the two kinds of licenses. Exclusive, as a name suggests, that is we have seen in one of the module, we have requested you, right, to just check. It is in the future areas of IP, in that we have requested you to check that whether what is the meaning of exclusive and non-exclusive. Probably you have gone through that. As the name suggests, this exclusive meaning is that okay, only, right, it's the right is given to only one party, only one entity. So one that the owner is transferring right to only one party, that is a exclusive licensing is there. And non-exclusive licensing is that you are giving the rights to more than one parties. If you are giving the rights to more than one parties, it is called as a non-exclusive license. So it depends on that particular technology under consideration. You have to determine whether you want to do a exclusive licensing or you want to do a non-exclusive licensing. But one just observation or one just fact I can share here, that if somebody want to develop technology fast, then they opt a non-exclusive licensing, because at a time you are making availability of that particular technology to more than one entities. You are creating competition within that particular group, and because of competition obviously that technology grows faster. And so generally if you want to develop any technology very fast, and suppose you yourself are ready with a next product depending on that further development, then obviously that is one strategy you can think of. Non-exclusive licensing is a best way. So that kind of thing is there. Now then the geographical extent is also important, that whether you want to do the worldwide license, that is you are giving rights to the person or parties which are all over the world, or you can keep it a very country specific. That is again the geographical extent you can determine, and you can do the licensing depending on that. Then the third way, that is rights license. That is, either you can give rights for manufacture, sale and use, or you can give rights for only manufacturing, or you can give right only for a sell, right, the distributorship and all kind of thing, that only is what we can say sure. You can give right to only use for the purpose of what we can say, they can use that particular invention for their own benefit, that only right you can transfer. And then the most important, the last one, that is a import. So you can give right to import only. Now what the thing is happening here is that most of the time patent is filed suppose in USA, and say that the other what we can say, the patent, that is other nations in which the patent is filed is, say for example India, China, and then the you can take example of Europe. Okay, so suppose the owner, means that inventor is from USA and he has taken a patent, or he has applied in the patent offices of India, China and Europe. Now what the thing happen is that now the possibility is that the person can do the things like he can give manufacturing in China, only manufacturing rights in the China, he can just think of an organization who is good in that manufacturing, and then the product can be as the patent is filed in India, they can import ready product and they can start the marketing. So importing rights are given to some company in the India, and that company will take care of import and sale of that particular product. So that way the rights can be divided, and accordingly, means that and therefore you can imagine that how strategically patent filing should be done, that you should know that where you are going to manufacture it, where you are going to sell it, all that kind of thing, where it will be only used, so that that particular already existing organization can use it successfully for their products and all kind of thing. And so we say that patent strategy is very important when you are filing that patent. Okay, so this is what we can say the licensing. Now what are the different key considerations for a licensing? That you should see when you are doing licensing, obviously that contract plays a very important role, agreements and contracts. So there are so many terms and conditions and all that thing, you have to think very critically, you have to think about that thing. The few only I can cite here, that how the payment will be there, what exactly will be licensed, what are the rights given for that party, whether there is a grant back policy followed or not, right? What about the confidentiality clauses? What if any dispute arises, whether you are using arbitration, or what exactly the way to resolve that dispute? If any serious condition arises, then what is the jurisdiction? That everything you have to mention in the contract, right? And it should be done very critically. Licensing is like if you see you will say that okay, contract agreements are available online, I just click on the button and I can get the draft of the contract. You will get a broad draft of the contract, but when you are working on the licensing, you have to think so micro level, you have to think, considering that technology, the party to whom you are transferring the right, you have to do thorough study of that whole thing, and then you have to decide on that whatever the clauses you have to include into that contract, right? It's a very tedious activity. Okay, so you have to just work on that thing, and then very carefully you have to take care of that licensing activity. Then payment of mode can be a lump sum mode can be there, down payments can be there, then milestone payments can be there, or some royalties can, there are so many ways are there. So you have to determine everything when you are transferring that rights through the licensing, right? Then time, for how many years you are giving that licensing. We know that okay, patent life is for 20 years, but you may give that right for 5 years only, for 2 years only. So you have to decide on all these things, right? Or what will be the share in the profit, everything, just examples I have given, but there are so many things you have to decide on that thing, and accordingly the licensing agreements or contract should be drafted. So this is what the licensing. So we have seen internal development, then we have seen the licensing. Now the third one, that is a joint ventures or a partnering. Now what is that joint ventures or partnering is that for the patent transaction, right? So you can think of, so you have invented something, now you are a owner of a patent, right? You are having rights of over that particular invention. Then instead of licensing, you suppose you don't have that, you are not an organization, so there is no chance of internal development and all kind of thing. You are not interested in licensing, but you are thinking that okay, I will do the joint venture. Then in that case, you can think of a partnership, you can think of what we can say the good partners, right? So that the process, that whole what we can say the process is a complementary, and that joint venture you can think of, and then you can divide on the obviously the roles and responsibilities. And here again, if joint ventures are there, partnering is there, again agreements and contracts will play a very very important role, right? Very carefully, obviously, means though you are a friend, right? You might be a friend and you are thinking of doing a joint venture. Be careful when you are entering into any of this thing, right? We know that finance, when finance is involved, you should be very careful, you should be very practical, and you should keep, means you should write down all things on, it should be black and white, that is very clear. Write down the contracts, sign, make it as a legal, what we can say, a document, and you just be follow that particular documents, right? It is always better to do that rather than entering into the dispute letter and it will create a mess. It is always better that contracts will be created. You should be very clear on that rules and responsibilities. Everything should be there in the contract. So whenever you are thinking of a joint venture or partnering, you just follow that thing, and then you can just develop your invention further for the ready to market kind of a product, and then marketing of that thing. So this is what the third way. Now the fourth way is that a startups or a spin-offs. Now what exactly you can do here is that generally startup, like we know that Startup India is a big event going on. Now what is that startup is? So what the thing is happening is academic institutes, they themselves have the incubators. What is incubator? Incubators are nothing but the very secluded environment, very secure environment. Okay, very important, it is a secure environment. Now whatever technology is developed within the academic institute, it is still in a budding stage, right? The technology is developed, patent is filed, but for going into the market, for marketing that particular technology, you have to develop a prototype, right? Then you have to, after prototype, you have to think about a scale up. All this very important stages are there. Now in such a, what we can say, for that critical development, you require a very secure environment. Why is a secure environment is required? Because you may not able to compete with the competitors who are already established in the market, right? So to keep you safe from this, it is always better that in the incubator you will get a good facilities. Now what kind of facilities you get incubator? If you have seen any incubator, what you get? You get the space, then you get the technology related some instruments and all kind of thing is there. Then you can explore that within, means for example, if IIT is there, obviously what the thing will happen, that resources are there in IIT, right? So you can use that resources to develop your product from that very invention level up to the prototype. You require so many resources, you will require mentoring, right? You will require that a very costly instruments and all kind of thing. Obviously in the incubator you will get very easily access to that kind of thing. That is a one important thing. Next important thing is that incubators are set up in a such a way that they can help you in creating a network, right? So if you want some help through network, then they can make the network available for you. That is again the second important thing is. Third important thing, I have already told you, that is a space related issue is there. You will get the space very easily available. That is an important thing. Then next, that is a fourth is like a marketing and all kind of thing is there, or some IP related things are there, or some other what we can say important finance related some information you want. Incubators organize some sessions so that through that sessions, through expert, you can get the information about that particular thing. Then obviously the important thing is funding, right? Incubator gives you, yes, the seed fund is made available so that you can work peacefully on your that particular technology, you can develop that thing, and if something in your hand, you can just show to the angel investors and all kind of that other resources for funding. Banks are there, so for them you can create something through the seed fund, and then you can further grow your technology. So that way, that startups through incubators, like they can get a benefit from that conducive environment, and they can develop the prototype, and then they can move on further to develop that particular product, right? So that kind of what we can say, that things are taken care by the that startup kind of environment, which is made available in the that particular academic institute, or there are research parks are there. So whatever the facilities are created through that, the things will be made, what we can say, that can be explored or exploited. Then the thing is that for bank loans, again you can take help of IP insurance and bank loan. I will just give you some points related to that. Here what the thing is happening is that, suppose you want a bank loan, we know that okay, based on the assets bank gives a loan, right? That we are very clear about that thing. Now how you can use a IP for a bank loan? You can just show the IP valuation. We have just taken a brief idea about that IP valuation in one of the modules. So if you can establish, right, that this is the value of my IP, then based on that IP, definitely banks give you the loan, right? So you can explore that particular thing, right? And you can take the loan. Now what about the insurance, like startup and insurance we are talking about, what kind of thing is there? Sometimes it is possible that you have taken all caution, you have done FTO search, you have done perfectly all procedures, but by mistake, if any legal things come up, if you attract some infringement related issues, right, then in that case, related to IP I am talking, if that infringement issues come, then it is always what we can say, litigation is a very costly. So it is suggested that you can do insurance based on your IP, right? The practice is already followed in many of the academic institute. IP insurance is taken so that what the thing can happen is that if by some bad luck, if something, that situation like that if arises, this insurance will help you to take care of a litigation cost, right? And so IP insurance facility can be availed. Then loan, I have already told, based on the IP you can just think of a loan, right? Now, so this is what we can say, the 4 pathways are there, like a internal development, we have seen that how it works. Licensing, we have seen then exclusive and non-exclusive licensing. We have seen the country specific licensing or worldwide licensing, and then we have seen the particular activity related licensing, like only manufacturing, only use, right? We have seen that thing. Then the joint ventures or partnerships, and then based on using this arrangement you can develop your technology. And the 4th we have seen, that is a startups or a spin-offs, right? Now these are the 4. There are so many other things are there, but you just remember these things are available. If you think of filing a patent, and now you have filed patent, you want to commercialize, you can think of this minimum these 4 ways to commercialize your technology, right? Now after going through this, you can just watch this interesting video about how the IP commercialization is done. Please watch.
This is one in a series of videos about intellectual property and you. Once you have registered your intellectual property, commercialization of your IP can be a way of bringing it into the marketplace. It is also a business strategy that can be used to grow your business and increase your future profits. 2 options you can use for commercializing your IP are franchising and licensing. Let's have a closer look. Franchising is based on a legal agreement between a business owner, franchisor, and another individual or group, franchisee. The franchisor grants the franchisee the right to use the franchisor's proven business model and associated IP in exchange for an agreed fee. The franchisor will also provide initial and ongoing training and support. Franchising your IP rights may be a low-risk and low-cost way of expanding your proven business model, growing your business, and providing additional revenue. Licensing is a legal agreement between an owner of IP, the licensor, and one or more individuals or companies, the licensees. The licensor grants IP rights to the licensee without transferring the ownership of the IP in exchange for an agreed fee. The specific terms and conditions of the license are detailed in a license agreement. Licensing your IP rights may be an effective and low-risk way of growing your business, improving your products or services, and an opportunity to enter new markets. Remember, if you are considering franchising or licensing your IP, you should seek the advice of legal experts and/or consultants.
Okay, I hope you enjoyed this video. With this, we come to the end of this session. See you in the next session. Thank you.